listing agent Dustin holds an open house and puts air fresheners all over the homes so that the pet odor is not so noticeable. Dustin advertises hardwood floors throughout that are covered by carpet needing to be replaced. Of which hazard should Dustin warn customers of the open house? A. Radon. B. Urea formaldehyde insulation. C. Lead. D. Biohazard from pet urine. Oh, that's right. Yep. So it would be D. Biohazard from pet urine. So I'll put the explanation in the chat, and then actually I'll put the question in the chat as well. Good job. Perfect. Next one. An agency disclosure is necessary to let the A, client know the agent represents her. B, seller know the agent represents the broker. C, customer know the agent represents her. Or D, buyer know the agent represents the broker. So an agency is necessary to let the who know. Right. So it would be client know the agent represents her. That is what the agency disclosure form is for. Cool. Okay. When showing a listing, a sales agent is asked about the condition of the basement. Got it. Okay. I wonder if it's my connection. Hopefully it's not. When showing a listing, a sales agent is asked about the condition of the basement. Without having seen the basement, the agent states that, to the best of his knowledge, the basement is free of dampness. In fact, the basement leaks steadily whenever it rains. The agent most likely has committed A, misrepresentation, B, fraud, C, intentional misrepresentation, or D, no error. This is protecting the homeowner's interest. Feel free to put your answers in the chat. So do we think it's A, B, C, or D? So it would be A, misrepresentation. So the agent has misrepresented the condition of the property and for what it is. Therefore, it neglected to look at the condition of the basement. All right, next question. Which level of radon is considered the maximum acceptable level? 10, 6, 8, or 4? So which level of radon is considered the maximum acceptable level? Right, let's say six. Okay, so radon levels over 4 are considered to be very unsafe. So the correct answer is 4. Okay, next question. Nick is purchasing a property and asks the real estate agent if the seller has to pay the property taxes for the part of the year when the seller owned it. The agent reassures Nick that the seller pays for up to and including the day of title transfer. How will Nick realize payment for the seller's share of the annual property tax? A, the check goes to the auditor. B, it will be a credit to the seller. C, it will be a credit to the buyer. Or D, the buyer receives a check at closing. So the credit will go to the buyer. So in this case, the credit goes to the buyer. Okay, next question. Agent Aaron is showing the seller's property to a prospective buyer who he has also represents as a buyer's agent. While touring the home, the seller tells the prospective buyer that the basement is dry and has never flooded. Aaron remembers that during a recent rainstorm, the seller told the agent not to show the property because the basement had flooded. Under this circumstance, what would be the most appropriate action of dual agent? Is that A, the agent should do nothing unless the buyer decides to make an offer. B, the agent should speak up and correct the misinformation. The agent owes the notice of material fact to both the buyer and the seller. C, the agent should not dispute the seller's word. The agent has an obligation of loyalty to the seller's best interest. Or D, the agent should say nothing. Being quiet absolves the agent of liability. Hmm, which one do we think it is? So it would be B. The agent should speak up and correct the misinformation. The agent owes the notice of material fact to both the buyer and the seller. Juanita is about to buy a house that was built prior to 1978. The seller should give her which disclosure? Is that A, lead-based paint disclosure form, B, Miranda warning, C, closing statement, or D, truth in lending statement? Oh no. All right. So Anita is about to buy a house that was built prior to 1978. The seller should give her which disclosure? It's going to be the lead-based paint disclosure. Anything after 1978, you do not need the lead paint disclosure. Okay. All of the following may be places where asbestos could be found in a single family home that is 50 years old, except A, in exterior siding, shingles, or roofing. B, vinyl flooring material installed when the home was built. C, recently purchased treated lumber for use in constructing a deck. Or D, an insulation sprayed around pipes and ducts or an attic insulation. So all the following may be places where asbestos could be found in a single family home that's 50 years old, except where? Feel free to put your answers in the chat. Let's see. All right, so it'd be the recently purchased treated lumber for use in constructing a deck. That would not be needed to find asbestos. Right, next question. Which document is required by RESPA to illustrate the cost of closing the real estate transaction? Is that A, disclosure of the APR, B, property appraisal, C, loan estimate, or D, closing statement? So which document does RESPA require? I think it might be either loan estimate or closing statement. All right, so RESPA requires a closing statement to illustrate the cost of closing in the real estate transaction. The disclosure of the relationship in which one party acts for or represents another under the authority of the latter is known as A, actual notice, B, agency disclosure, C, customer representation, or D, abatement. And that is going to be agency disclosure when the agent represents their client. And there is no such thing as a customer representation. All right. Cool. Let's see. What should our next topic be? Mm, We can do, when do we not do a lot of? Transfer of title. A title search can be conducted by A, an attorney at law, B, the loan processor, C, a buyer's real estate agent looking after the client's interest, or D, anyone. So a title search can be conducted by who? Hmm. So it could be a title search can be conducted by anyone. Anyone can go to the public record and search for a title. If the question asks who prepares evidence of marketable title, then that is going to be at at law. Okay, next question. Standard title insurance covers A, all title defects, B, recorded title defects, C, unrecorded title defects, or D, defects disclosed by a competent survey. So standard title insurance covers what? That is going to be recorded title defects. Okay, so a written instrument transferring the grantor's ownership of or interest in real property is known as A deed, B easement, C mortgage, or D title. And that is an A deed. So a written instrument transferring the grantor's ownership of or interest in real property is known as a deed. A buyer decides to buy a house and all the furniture in it. The buyer and seller should execute A mortgage and promissory note, B deed and bill of sale, C deed and a mortgage, or D habendum clause. So it would be deed and bill of sale. To sell the furniture, they will put that on the bill of sale and the deed will transfer the property. When a buyer asks the seller to provide title insurance and they agree, who picks the title insurance company? A, buyer, buyer's agent, B, lender and bank, C, either seller or buyer, or D, seller. When a buyer asks the seller to provide title insurance and they agree, who picks the title insurance company? Mm, That would be D, the seller. So the owner title insurance policy would be chosen by the party paying for the policy. Okay, cool. Those are only 5 questions. All right. Let's see. Let's do licensing requirements. On the anniversary of the license being issued, a new broker or salesperson must be able to provide proof of A, membership in Board of Realtors, B, the post-license sales review class, C, a minimum number of transactions, or D, the 30 hours of continuing education. So on the anniversary of the license being issued, a new broker or salesperson must provide proof of this post-license sales review class. So within your first year of being licensed agent, you are required to do post-licensing education. All right, next question. What would cause a real estate sales applicant to be denied permission to sit for the Ohio real estate sales exam? Is that A, an arrest for bank robbery, B, a parking ticket, C, being over the age of 65, or D, having violated any civil rights law regarding real estate within the past 2 years? Mm, maybe. So that would be D, having violated any civil rights law regarding real estate within the past 2 years. A broker sent salesperson B's license back to the Ohio Division of Real Estate. What statement below is true? A, the broker must send the agent a registered letter 30 days before sending the license back because license laws require the broker to give 30 days notice. B, the agent requested in writing that the license be sent back to the broker, has 3 days to honor the request, and must inform the agent in writing that the request has been acted upon. C, the broker cannot send the agent's license back until after the agent's birthday. Or D, if the Ohio division requested the return, the broker does not have to send a letter to the agent. So a broker sent salesperson B's license back to the Ohio division. What statement is true? And that is going to be B. Since the agent requested that the license be sent back, the broker is required to do so within 3 days. If a broker returns a sales license to the Division of Real Estate, the salesperson can get it back by A, taking a 10-hour post licensing course, B, paying a reinstatement fee, C, taking 30 hours of continuing education, or D, retaking all pre licensing courses. And that would be B, paying a reinstatement fee. So a salesperson can be placed on inactive status indefinitely. But in order to return the license, to activate the license again, to make it active status, they will need to pay a reinstatement fee. A new real estate sales licensee needs to renew his or her license. A, on December 31st of the third year after the license was issued. B, on his or her next birthday following date of issue and every 3 years thereafter on the licensee's birthday. C, 3 years from the date the original license was issued. Or D, 3 years after taking a 10-hour post licensing course. So within a new real estate sales licensee needs to renew his or her license on his or her next birthday following date of issue and every 3 years thereafter on the licensee's birthday. If an agent had his broker send his license back to the Ohio Division of Real Estate because he took a job that left him no time to sell real estate, his license is A, suspended, B, on deposit, C, canceled, or D, inactive. And that is going to be D, inactive. Right. A salesperson joined the Army. The agent's license is A, on inactive status, B, on deposit, C, revoked because the tour of duty is more than 2 years, or D, in escrow. And it would be on deposit. So a salesperson joined the army, the agent's license would then be on deposit. Okay, next question. Who is responsible for renewing a sales agent's license after 3 years? A, sales agent's broker, B, sales agent, C, Ohio Real Estate Commission, or D, Ohio Board of Realtors. And that is going to be B, the sales agent. Agents are responsible for renewing their own license. If a sales agent does not wish to practice real estate on a full-time basis any longer, his license is returned to the Division of Real Estate and placed in escrow, in deposit, on an inactive status, or on canceled status. So it can be placed on an inactive status. To be eligible to sit for the Ohio real estate sales exam, a person must A, be honest, truthful, and good reputation. B, have not sold a home within the last 2 years. C, be under the age of 65. D, be an Ohio resident. To be eligible to sit for the Ohio real estate exam, a person must be honest, truthful, and have a good reputation is the correct answer. All right, so there, it looks like there's a minimum age of 18 years old, but there is no maximum age. Okay. Cool. Let's do one more. Any specific topics that you guys want to go over? Well, this is brokerage. Leasing and property management. All right, let's do property ownership. Okay. Mr. Green gives a life estate to Sandra. Upon Sandra's death, the estate is to go to Mr. Blue. Mr. Blue's interest is known as A, contract for deed, B, reversionary interest, C, leasehold interest, or D, remainder interest. And that is going to be the remainder interest. Reversionary means going back to the original grantor. Leasehold just gives temporary rights. And contract for deed is another name for a land contract. So remainder interest is the answer. So Jack gives a life estate to Jill for so long as Bob lives. Upon Bob's death, the property will pass to Larry. What are the interests of Jill and Larry? Per atreve with reversion, sorry. B, ordinary life estate with remainder. C, ordinary life estate with reversion. Or D, per atreve with remainder. Mm-mm-mm. Jack gives a life estate to Jill for some life. Actually, so that's gonna be per atreve with remainder. Jack will not get the life estate back. Jill is the life tenant, and Bob is measuring of life. When the measuring of life is someone rather than the life tenant, the life estate is per atreve, and Larry has a future interest in the property as the remainder man. That's a confusing one. It's a good explanation. Okay. Which is both a lien and an encumbrance on property? Is that A, mortgage, B, a deed restriction, C, a license, or D, an easement? So which is both a lien and encumbrance on property? And that is going to be a mortgage. Well, all liens are encumbrances. All encumbrances are not always a lien. A deed restriction, an easement, and license are all encumbrances or burdens on the property. Well, the mortgage is the only burden that has financial claim. So a mortgage is a type of lien. Which is not an example of common area in a condominium? So which one is not an example? A, land, B, living room, C, swimming pool, D, laundromat. And that's going to be B, a living room. Which is not real property? A built-in dishwasher, B, drapes, C, a sub pump, D, an in-ground swimming pool, which is not real property. And that's going to be B, drapes. Those are personal property. Which is not an approved tenant to real property? A, easement, B, chattels, C, deed of trust, D, mineral rights. So which is not an approved tenant to real property? That's going to be B, chattel. A chattel is personal property and does not stay with the land. Everything else would then stay with the land. All right. The highest, best form of ownership interest in real estate is called a fee simple conditional, B, a leasehold estate, C, a life estate, or D, a fee simple absolute. And that is going to be D, a fee simple absolute ownership means the owner owns the property absolutely and can do whatever they want with it. A property is classified as either real or A, easements, B, fixtures, C, personal, D, implements. So all property is classified as either real or what? Real or personal. Okay. The legal description of a property based on points of beginning Distances, directions, and degrees is A, meets and bounds description, B, government rectangular survey, C, lot and block description, or D, recorded plat of subdivision. So the legal description of property based on points of beginning, distances, directions, and degrees is a what? I can't remember. That is going to be meets and bounds description. Must start at the point of a beginning, sometimes usually natural monuments as markers, and then end at the same point is going to be your meets and bounds legal description. An example of natural attachment to real property is A, a garden bench, B, an electrical power pole, C, landscaping, D, a chain link fence. So natural attachment to real property is landscaping. So of all the answers, landscaping is going to be your best choice. All right, good job. Thank you so much for joining.